who gets to be the personal representative in a probate case in Florida. So the personal representative, that's the person that either is named in somebody's will to serve as the executor after they pass away, basically to administer the estate, distribute the assets, make sure that a person's last wishes are carried out. Or if there is no will, then the court is going to name who the personal representative is going to be. Now in Florida, we use the term personal representative. I know a lot of other states might use the term executor or administrator or something like that. In Florida, we use the term personal representative. So who gets to be the personal representative? It's broad and limited in the sense that the statute, Florida law, says who gets to be the personal representative. It doesn't necessarily have to be a Florida resident, so it can be somebody who lives in another state or even another country. It doesn't even have to be a U.S. citizen, so you don't even have to be a citizen of the United States to do it. But if you're not a resident of Florida, so if you're not going to be in the state of Florida, then you have to have some sort of family lineal relationship to the person who passed away. So most commonly, it's going to be a spouse, might be a child, it could even be a niece, nephew, brother, sister, something like that. But what we see a lot of times is somebody, lives in Florida, and maybe they don't have any family member, or they want their best friend who lives in New York to be the personal representative. Well, if that person's not a family and they're not a resident of Florida, then most likely they're not going to be able to be the executor or the personal representative. So that's really important if you're doing a will, or if you've already done a will. You want to make sure that the person that you've named is in fact a resident of Florida, or that they're a family member. Other than that, basic things, they got to be over the age of 18, can't be a minor. They need to have mental capacity to be able to do it. And the one restriction is they can't be a convicted felon. So if they're a convicted felon, regardless of whether they're a resident or a family member, they're not going to be able to be the personal representative. So now you're probably going to want to choose somebody who you trust that's going to administer things. I know this is a difficult decision for a lot of people, especially if you want your kids to do it, but maybe you've got multiple children. We see sometimes where people will choose two people. They want, their son and daughter to be what's called co-personal representative, where they're both the representative. This works out fine sometimes, but then you also have problems where, if they can't agree on what to do, then you kind of come into a stalemate because they're just gridlocked. They can't figure out, what to do. Once the son wants to sell the house, the daughter doesn't want to. And if you haven't spelled that out, now there's a fight over that. So it really depends on the circumstances. Depends on your situation, whether it makes sense to have co-personal representatives or not. Some people might have their attorney, but that's very, very rare. Most of the time, the attorney is not going to serve as the personal representative. So, if you've been named as the representative, you're going to want to hire a probate attorney to help you go through the process. But that's really it when it comes to who can be the personal representative in Florida. A resident, or if they're a non-resident, they need to be some sort of family member, and they really just can't be a convicted felon.